Okay, we're going to talk about Unit 3, and Unit 3 is where most all of the Supreme Court cases fall. So again, you could use a evidence from a required Supreme Court case on your argumentative essay. It could be your second piece of evidence. Remember, your first piece of evidence has to come from one of the three documents given to you in the prompt. Your second piece of evidence could come from the other two pieces of evidence given to you in the prompt. You can't use the same piece of evidence twice. We know that, right? But you could use one of the other two pieces of evidence that you didn't use for evidence one, or you could use any of the other six required documents that aren't on the prompt. Those are fair game. Any facts or evidence from those six required documents, or anything from the required Supreme Court case. You can use a decision uh, and the reasoning for that decision, for the evidence on your evidence two, second piece of evidence on your argumentative essay FRQ. You can definitely use that. Or you could use anything else relating to your study of AP government. So things like federalism, or the electoral college, or federalism is in the Constitution. That would be a constitutional. If the Constitution, I would not use the Constitution twice. Like I wouldn't use like Amendment 1 and then, I don't know, Amendment 15. Okay, if the Constitution is one, use the Constitution, but try to come up with another piece of evidence outside of the Constitution. So like the electoral college, or the um, could be, the, I think, what's not in the required documents, um, election process or something like that. Okay, so that would make sense. All right. So let's go over the Unit 3. This is basically civil rights, civil liberties. Get into a lot of the courts. Um, Gonna get into the courts, a little bit of the courts. Again, a lot of these Supreme Court decisions are in Unit 3. 14th Amendment is going to be huge. We're going to talk about that. So let's, again, I think it's important if you can start outlining this information in a notebook that you could use on the test. Hopefully you've gone through the 9 required documents and kind of outlined the key pieces of evidence from that, the key uh, point of views of the authors, what they're getting across, what their main points are. Also for the required Supreme Court cases, and then units 1, 2, and 3. Make sure you go over the notes too. Like, these reviews are just reviews. They're just that. They're just reviews. Like, there's something they didn't talk about in the reviews that are still prominent to the AP course study. Like, we didn't talk yesterday about the trustee role, the delegate role, the Politico role, right? Key vocabulary terms, things like that. So make sure you go through all of uh, the notes that are posted, the Unit 1 notes, the Unit 2 notes, and the Unit 3 notes that are posted on the group. So Article 3 of the Constitution is the establishment of the judicial branch. So the judicial branch is Article 3 of the Constitution. It says that, the Supreme Court, all judicial powers will be vested in the Supreme Court. And then you have Federalist number 78, which argues for independence, the independence and judicial review, the power of judicial review for the court. It's kind of their check. It's the check on the legislative branch and the check on the executive branch. And it's necessary, but it's also necessary for independence of the judges to freely do their job, to interpret the Constitution. Okay. Civil liberties and civil rights. Again, we're going to get into the 14th Amendment. It's huge. 14th Amendment, make sure you understand that. There's really it says two clauses here. There's really three clauses. You have the citizenship clause first. Basically says that any person born in the United States is a U.S. citizen. Okay, so it establishes any person born or naturalized in the U.S. is a U.S. citizen. So that is important because then the next two clauses are going to say that states cannot take away rights of citizens, who we know is any person born or naturalized in the United States. States cannot limit or infringe the rights of citizens without due process. So it prohibits states from taking away rights of really back then minorities, right, without going through due process of the law. This was a huge due process and equal protection. Again, that was a huge concept in letter from Birmingham jail, right? Because the last clause, the equal protection clause, says that all people will be equally protected under the law. But the law doesn't apply to only rich white men. Right? It applies to all citizens. Every single citizen of the United States is equally protected under the law. Discriminatory laws are no longer legal, right? It outlaws any form of discrimination against people, that we are all equally protected under the law. And then this idea of selective incorporation is the process of going through and extending those rights to the states. So extending the Bill of Rights protections to the states. And we looked at a few of these Supreme Court cases. Donald versus Chicago takes the Second Amendment and applies it to the states. Gideon versus Wainwright takes the Sixth Amendment right to an attorney and applies it to the states. And one I'm missing. There's one other one. Roe v. Wade. Roe v. Wade takes, which isn't technically listed in the Constitution, but it is it's an implied power, this right to privacy, which is implied through an earlier case, Griswold versus Connecticut, that yes, actually we do have this right to privacy through certain powers in the Constitution, First Amendment, the Third Amendment, the Fourth Amendment, the Fifth and Sixth Amendments, the Eighth Amendment, and basically says that we cannot have our right to privacy taken away by the states, right? And in that case, it was a state law prohibiting women from obtaining the right to an abortion. Right to the right to privacy extends to a woman's right to obtain an abortion. Okay. Essential questions. This is what we're going to go over. How do the branches of the national government compete and cooperate in order to govern? To what extent have changes of the powers of each branch affected how responsive and accountable the national government in the 21st century? To what extent does the U.S. Constitution and its amendments protect against undue government infringement on essential liberties and from individual discrimination? And how have U.S. Supreme Court rulings defined civil liberties and civil rights? So remember that civil liberties are essentially the Bill of Rights. Civil liberties protect the people from undue government interference. Okay, like the First Amendment says that in a free democracy, the right to a free press shall not be restricted. So Congress shall pass no law respecting a establishment of religion. Okay, so it basically puts limitations on the government from infringing or taking away people's rights. Okay, Second Amendment says that the right to bear arms shall not be restricted. Okay, so again, there are limitations. Congress shall make no law respecting respecting an establishment of religion or prevent the free exercise thereof. Congress shall make no law restricting free speech, free press, freedom to assemble, and freedom to petition. So there are limitations put on government. Civil rights are extensions of rights to groups of people that have been discriminated against. So you think of like the 15th Amendment, that is a civil right. It's extending a voting right, which already exists, to African American males. The 19th Amendment takes the right to vote, which already is a right. It's a right granted to the people, but it extends that right to women. So the civil liberties protect the people from undue influence from the government, from government basically infringing on your rights, and civil rights extend specific rights to other groups. Does that make sense? Any questions about that? Actually, I think it's important to understand the difference between civil liberties and civil rights. Okay. Design of the judicial branch. We talked about this a little bit yesterday too um, in our institutions of government. Article 3 of the Constitution establishes the judicial branch, right? Which we know there was no judicial branch under the Articles of Confederation. So establishes a national judicial branch and establishes the Supreme Court as the head of the judicial branch. Okay. And a three-branch separation of powers, Article 1, Article 2, and Article 3. Judicial review. Judicial review is really kind of a power that's implied by the Constitution, but it's really established by the Supreme Court case Marbury versus Madison. 1803, one of the very first Supreme Court cases. Marbury versus Madison says that the Supreme Court has the power to overturn actions of the legislative and executive branches. It's the main power. It's what they're talking about in Federalist number 78. It's the main power of the branch to interpret the laws passed by Congress and the actions of the president and the executive branch, and to strike those down as unconstitutional. That if you recall, just a few years ago, Donald Trump and his immigration ban in 2018, I believe, was struck down by the courts as unconstitutional. Like, you don't have the power to do that. You don't have the power to regulate immigration in the United States. That is an act of Congress. Congress can control who comes in the United States. They can control the naturalization process, not the president. So they struck that action down. I think even the Engel versus Vitale case, they're striking down a state law. So we think like, yeah, it's just acts of legislative branch and acts of the executive. It also extends to laws passed by states. That's a great example of judicial review of the Supreme Court striking down the New York law requiring daily prayer. That is a great example of judicial review. And then Federalist number 78. Federalist number 78, written by Alexander Hamilton. This is, again, he's arguing for the independence of the court, independence of the Supreme Court, and he argues for life terms. It's important to have permanency in that position in order to do their job. And it's also important for them to be removed from political pressures. So they would be appointed by the president. They would serve for life. All right. Importance of precedents and stare decisis. This is definitely important. Precedents are decisions made by the courts which set a precedent, set a standard for all of the other courts to follow. Okay, so for instance, we'll say that in Roe v. Wade, right, the precedent was set that an abortion is protected by this right to privacy. It didn't set the precedent of privacy. That was already established. But that the fact that a woman's right to obtain an abortion was protected under this right to privacy that's implied by the Constitution. Okay. Can you guys hear me okay?
You're really choppy.
I know.
Yeah, you're freezing a little bit.
I'm sorry. It's my internet connection. if you can't hear me or if I lose you, I'll be back on in a minute. So precedents, right, are the standard that is set by a Supreme Court case. Stare decisis. So once a precedent is set, that usually is followed by future courts. So when the precedent is set by a court, the decisions that come to the court regarding that specific issue are usually followed by the court. Stare decisis is let the decision stand. It's the reliance on precedent when making Supreme Court decisions or making court decisions. Okay. They can overturn those precedents. If you look at it's not a non-required case, Plessy versus Ferguson, but that set the precedent for separate but equal, right? But then it overturns the. Hey, I don't know. So the Plessy versus Ferguson sets the precedent for separate but equal, but it's later overturned. That precedent is later overturned in Brown versus Board. So, it doesn't mean that it can't be overturned, but generally the Supreme Court, because their job is to interpret the Constitution, those interpretations will stand until a court decides to overturn it. Okay. Any questions about that? Right, precedent, Plessy versus Ferguson. That was the precedent set for separate but equal. Said that separate but equal was constitutional. Right, separate, segregated facilities were constitutional as long as they were equal. But that was later overturned in the Brown versus Board decision. Stare decisis, Roe v. Wade, as I mentioned, that kind of sets the precedent for the right of a woman to obtain an abortion. But it does kind of follow this. Remember that the principle of privacy was established in the case Griswold versus Connecticut. We briefly talked about that, but basically Connecticut had a state law that banned the use of contraceptives in order to reproduce children, right? They wanted to increase population. It was brought to court, and basically the Supreme Court struck that state law down and said you can't tell people what to do in their own homes. Right to privacy, and that was later. The right to privacy was extended in the case Roe v. Wade. Okay. So loose constructionist and strict constructionist. This is essentially two key terms here. We're talking about the principle of basically interpreting the Constitution as is, right? That would be a strict construction of what the Constitution says, or the interpretation of the Constitution. Okay, so a loose constructionist is going to interpret the Constitution. They're going to use their position to interpret the meaning of the Constitution and then make decisions on present standards. Okay, so this would be judicial activism. A loose constructionist is judicial activism, that basically a Supreme Court judge uses their position on the court to make decisions extending civil rights. Gabriel. Sorry. So loose constructionist is judicial activism, where this is generally a liberal philosophy that a judge can use their position on the court to extend civil rights by interpreting the Constitution. So in the Supreme Court case, Brown versus Board of Education, right? A judicial activist would say that, separate but equal, this equal protection clause means that through their interpretation of the 14th Amendment of the Constitution, that segregation is not equal. Right? Segregated facilities and it's been proven that it is unconstitutional. It basically create a sense of inferiority amongst black children, and we're going to strike down that decision. We're going to strike down segregation by using the 14th Amendment equal protection. Okay, strict constructionists would argue this is a more conservative version. This is what is called judicial restraint. Okay, where a judge sticks to what the Constitution says. So if you take same-sex marriage, right? Same-sex marriage, which was taken on by the Supreme Court in 2018, but same-sex marriage, what does it say about same-sex marriage in the Constitution? Nothing. It says absolutely nothing about marriages in general or same-sex marriage, right? I don't even think that was really an issue back in 1791. So if it doesn't say anything about that in the Constitution, then it should be left to the states, right? The 10th Amendment, that's a 10th Amendment issue, and it should be left to the states. So strict constructionists often tend to defer those issues, those controversial issues, social issues, to the states and let the states decide that. That is a very conservative idea, right? Whereas a loose constructionist would say, well, technically the Constitution says that all people are equally protected under the law. And state laws that ban same-sex marriage are discriminatory. And discrimination is obviously outlawed by the Equal Protection Clause, the Due Process Clause and the Equal Protection Clause of the 14th Amendment. So we're going to use those clauses to advance the rights of gays, lesbians, transgender, bisexual, all that, right? So do you get the difference between those two? That's really important. Loose constructionists, this is what would be termed as judicial activism. Strict constructionist is judicial restraint. Okay, make sure you know the difference between those. Any questions? And this is just what we're talking about, right? This is exactly what I was just talking about. Judicial activism, the view of the Supreme Court justices can and should interpret the text of the Constitution. It's their interpretation of the Constitution. How would the Constitution be applied in today's standards, in today's issues, in today's social problems? What would the Constitution, what would the framers say about these issues? Okay. And judicial restraint is specifically, what does the Constitution say? If the Constitution doesn't say anything about same-sex marriage, then that should be reserved to the states. Let the states decide what to do with that. Okay. All right. How other branches can limit the Supreme Court's power? Constitutional amendments. So we know that the Supreme Court is responsible for interpreting the Constitution. Constitutional amendments can be proposed by Congress. So Congress can propose constitutional amendments to make changes to the Constitution, which would then change the interpretation of the Supreme Court's power, right? Judicial appointments and confirmations. We know that judicial appointments are made by the president, and he often looks for like-minded people, and the confirmations come from majority vote from the Senate in order to approve those. President evading and ignoring Supreme Court decisions, and states evading or ignoring Supreme Court decisions. So we know that the Supreme Court makes their decisions, but they often rely on the president, Congress, and the states to carry out and enforce those. Supreme Court has no power, and even says in Federal 78, has neither power of force nor will. They cannot force their decisions on the country. They cannot force their decisions on the states. They often rely on the president and Congress and the states to carry those out. So the president, Congress, and the states can choose to ignore that. And I think a perfect example is the Brown versus Board of Education decision, 1954. 10 years later, 2% of all southern states were desegregated. 10 years after the Brown versus Board decision, right? So the President Eisenhower just had to send the troops down to Little Rock Central High School, and Congress had to pass the Civil Rights Act to make it a federal law that discrimination would not be tolerated in the United States, right? And congressional acts. So I think all three of those are really responsible for carrying out and enforcing Supreme Court decisions. All right. Civil liberties, civil rights, talked about these. This is important. Civil liberties are protections we have against government interference that, like I mentioned before, Congress shall not establish a national religion. That is a protection that Congress won't force religion on us. And Congress will not prevent us from, or the national government will not prevent us from freely exercising the religion of our choice. So those are civil liberties. And then civil rights are extension of certain rights to previously discriminated groups, race, gender, disability, sexual orientation, extending those rights to previously discriminated group. Okay. First Amendment, I think this is important. Establishment Clause, Free Exercise Clause. We talked about the two Supreme Court cases involving this. Establishment Clause is Engel versus Vitale, right? Establishment Clause prevents Congress from establishing a national religion. School prayer, state law requiring school prayer was essentially establishing a religion, and therefore was struck down. The state law requiring the state law was struck down by the Supreme Court as a violation of the First Amendment. Establishment Clause, Free Exercise Clause says that Congress cannot prevent us from exercising the religion of our choice. So if we want to practice Buddhism, if we want to practice Hinduism, if we want to practice Christianity, Judaism, Catholicism, Islam, right? All those religions, we have the right to choose and freely exercise religion of our choice. Wisconsin versus Yoder, this was the Mennonite and the Amish community. Wisconsin state law required formal education till the age of 16. It was standard practice for Amish and Mennonite to remove their children after the 8th grade, 14 years old. So you have a state law conflicting with a religion. You know, there's the right to freely practice that religious activity, that religious tradition, trump the state law? Yes, it does. Right? So they ruled in favor of the Amish and Mennonite community. They could not make no compelling interest to requiring children to stay in school to 16 for Amish and Mennonite communities. The speech and press Supreme Court decisions, Tinker versus Des Moines, that is the freedom of expression, the wearing of armbands in school was protected speech. Schenck versus United States, this is one of the restrictions on speech. This is one of the cases in which the rights of the people are not upheld. In this case, Schenck was a part of the Communist Party and speaking out against the war, World War One, the United States involvement in the war, urging people to resist the draft. And they said that his speech was not protected because it was creating a clear and present danger during wartime. Any speech that creates clear and present danger can be restricted. The New York Times Company versus the United States, New York Times Company versus United States, is the Pentagon Papers, and the right of the people to know, the right of the people to have a free press is much more important than the United States covering up their involvement in Vietnam in Pentagon Papers. Okay, so in that case, they ruled for the Times. They had the right to release the papers to prevent, the United States government could not revoke prior restraint. Right, make sure you know what prior restraint is. It's the fact that the government was trying to prevent the papers from being released, right, restraining the publication of the papers prior to their publication. And in that case, the government can do that if they can prove that the paper, the press, the information is going to cause undue harm to the security of the United States. And in this case, could not prove that. So times we're able to prove. All right. Selective incorporation, due process, and equal protection. 14th Amendment. Super, super important, right? 14th Amendment. Again, we also talked about the citizenship clause. Any person born or naturalized in the United States is a U.S. citizen. First part of the 14th Amendment. Sorry. The due process clause. Stop. The due process clause, the requirement that citizens accused of crimes are given fair treatment throughout the entire criminal process, from arrest through trial and potentially appeal, so that the government cannot, particularly the states, right? Because we know that due process is in the Fifth Amendment. Fifth Amendment says that people shall not have their rights taken away from the government without due process. That protected the people from the national government taking away their rights. But it didn't say anything about the states. And as we know, the states began to pass Jim Crow laws, black codes, things like that. So that would discriminate against African Americans, former slaves. So the 14th Amendment says specifically, states cannot take away people's rights without due process. Okay, so it's striking down those Jim Crow laws and those black codes, and anything that took away a person's right would. And remember, this was passed in 1868. So, I mean, to say like it was effective would be a lie, right? There was still a lot of racism in the South up until really the Civil Rights Movement in the 1960s. So for 100 years, I mean, the Due Process Clause, it has good intention. The intention is that states cannot take away people's rights, but that is largely, hugely ignored in the South, okay, as we know. But it's still part of the Constitution, and the Civil Rights Movement basically uses the Due Process Clause and equal protection as their fire, as their evidence, right? It's what they're going to use to make their claim for equal rights, and eventually passage of the Civil Rights Act and the Voting Rights Act. And then the Equal Protection Clause says that all people will be equally protected under the law. All these are really important. Selective incorporation. We talked about selective incorporation, McDonald versus Chicago. A lot of people think that's a Second Amendment case. It's not a Second Amendment case. It's really a 14th Amendment case. It's basically, does the city of Chicago have the right to take away the Second Amendment? And the answer is no, they don't. Right? They don't have the right to ban handguns in the city of Chicago. They're doing it. The reason why they're doing it is to basically because crime and murder is at an all-time high in Chicago in the 1980s, 1990s. But restricting gun use, particularly the Second Amendment, the Second Amendment is incorporated to the city of Chicago. It's incorporated to the state of Illinois by means of the 14th Amendment. Because remember, the 14th Amendment says can't take away people's rights. Second Amendment is a right. Okay, can't take away their rights without due process. There's no due process here. Okay, so if a person goes out and shoots somebody, then they're going to go through the process of the court system, and then they can have their rights removed. They can have their rights taken away. They can't just take away someone's right to own a gun without due process if they're doing nothing wrong. And the main argument here was McDonald wanted protection. He wanted to protect himself from break-ins, which were very common and rampant throughout his neighborhood. So he didn't feel like a shotgun was necessary. He wanted a handgun to defend himself. So that was the issue there. Questions about that? This is really important. I think the 14th Amendment could very well show up on the test. It's a huge piece. 14th Amendment's Equal Protection Clause. Okay, this is the movements the letter from a Birmingham jail, 14th Amendment Equal Protection Clause, that's what he's fighting for. He's fighting for the inequality in Birmingham, right? The injustice in Birmingham, Alabama. And his main goal is that all people should have equal rights, that we should all be equally treated under the law, and we cannot have our rights taken away from us. We cannot be treated differently under the law. And then you have some of the other historical movements, the National Organization for Women, using the 14th Amendment for equal protection, pro-life movements, the LGBTQ. That was a big one. That was just a few years ago. Over Geffel versus Hodges, non-required Supreme Court case, but they use the Equal Protection Clause and the Due Process Clause to strike down the state laws banning same-sex marriage. That allowing some people to get married and some people not to be married is not equal protection under law. You want all people to be equally protected under a law that is discriminatory. And they use the Equal Protection Clause to strike down those state laws. Okay. Civil Rights Act of 1964. This is a result of the letter from Birmingham jail, the civil rights movement, obviously, right? 10 years after the Brown versus Board education decision, segregation, discrimination is still happening in public schools, right? Brown versus Board struck that down, but the states were not complying. So Civil Rights Act of 1964 makes it a federal crime to discriminate based on race, color, creed, religion, sex, or national origin. Okay. That's followed, I'm going to skip down here to the bottom, that's followed by the Voting Rights Act of 1965, which basically says that any barrier to voting is illegal. It abolished many legal barriers that were being prevented to prevent African American voting at the time of passage. It's the 24th Amendment bans poll taxes. That's 1964, I believe, 1964, 1965. So that bans poll taxes in the United States, and the Voting Rights Act bans any form of barrier to voting in the United States. Okay. And then Title IX. Title IX is the law passed by Congress requiring equal opportunities for females in education opportunities. Acts against discrimination due to sex in any athletic program, school, education, anything that received federal financial assistance or funding could not discriminate against females. So if you had male sports, you had to provide equal opportunities for females as a result of Title IX. All right. Affirmative action. So affirmative action, definitely need to know what that is. Affirmative action are government programs designed to increase equality of opportunity for minorities. Okay, we have talked about the causes of affirmative action, inequality in hiring and awarding of federal contracts for minorities and women. It was an effort to increase opportunities for females and women in education, employment. Those were the two main ones. The outcome of Affirmative Action Acts increased employment and awarding of federal contracts for minorities and women, increased admittance to college and universities for minorities and women. We talked about there was one restriction on this that you might need to know is the quota system. The quota system, Bakke versus California versus the Regents of the University of California, non-required case, but the use of quotas was a violation of the of racial quotas was a violation of the 14th Amendment because it was essentially reverse discrimination. Okay, so what affirmative action is if a white male and a minority, male or female, are equal, they have about the same qualifications, that it is allowed. It is legal to offer the opportunity to the minority. Okay. In that case, right, the white male often had better scores, better qualifications, and kept getting denied because they had to admit so many minorities. That's what quotas are, number, right? So in that case, that was essentially reverse discrimination, and the use of quotas was struck down by the Supreme Court. All right. That's all I got.
Mr. DeBoard.
Yes.
I was able to like go to my College Board account and I